Okay, good afternoon, class. I'm going to discuss with you today the free, appropriate public education entitlement that is guaranteed by the 14th Amendment. This civil right is defined as the provision of regular or special education and related aids and services that are, one, designed to meet individual needs of handicapped persons as adequately as the needs of non-handicapped persons, and two, are based on adherence to procedures that satisfy the requirements specified for one's educational setting with regard to one's evaluation, placement, procedural safeguards. So in the U.S. Code, Fape is defined as an educational program and related service that are individualized to a specific standard, then meet the standards established by the state, provided at the public expense and without charge. So for a school to properly provide Fape, the school must provide an education that includes specialized instruction, related services where necessary, one designed to prepare the child for further education, employment, and independent living. This last part is so important when it comes to the idea of inclusion, letting our students that have these learning challenges have some commonality with their peers. Obviously, they have the same goals, and though their educational journey may be different from their peers, it is so important that they have that commonality, that they have that inclusion, that they are on the same journey with those students. Okay, part two, we're going to look at the various laws that began to carve out space for the Free Appropriate Public Education Act. The first was actually, and surprisingly, the 1958 Captioned Films Act. This was intended, at least in part, to enrich the educational experience of deaf customers. The law, that's kind of the foundation. Then in 1959, the Professional Personal Act was passed, and it increased the types and amount of training individuals had to work with students that had different learning challenges. We also have another update in 1965. This is the Elementary and Secondary Education Act. This gave states access to grants from the federal government to enact these special services to help include these differently abled students. The big change, however, happens in 1973 with the Rehabilitation Act of that same year. This established non-discrimination requirements for federal agencies as well as state and local programs receiving federal assistance. So up until this point, it was an uphill battle to get your student to qualify for these services. And prior to this, obviously they were dealing with discriminatory practices, keeping them from their guaranteed right to pursue a fair education for their kid. In 1975, Congress passes some other public laws that are known as the Education for All Handicapped Children's Act. One of the big things that this does is it gives rights to the students and their parents that they have this equal protection underneath the 14th Amendment, continuing to try to bring equality to all United States families to have access to this law. The struggle to get everybody on board continues, and it finally reaches the Supreme Court in Board of Education of the Hendrick Hudson Central School District versus Rowley. The Supreme Court ruled that a free and appropriate public education should provide access to specialized instruction. This would be fought. Finally, the U.S. Supreme Court unanimously ruled on the rights of students with disabilities in Fape, and this was decided in Andrew F. v. Douglas County School District. The court held that Fape provides disabled students the right to more than just token progress from one year to the following year. And so Since then, there have been a few other modifications, but this really represents the base for the law as we have it now. All right. In conclusion, the benefits for the family is really lies in this idea of transparency. The law in its current manifestation guarantees that that the school in the state that they have complied with the procedures set forth in the Act. These procedures enable parents to examine school records, participate in meetings, and present complaints. This is such a huge benefit for these families that now they have a voice that is guaranteed by the federal government, and they are allowed to make their case. They're also allowed to examine the case that the school may be making to augment and or deny them these important services. So that is the benefit of to the families and to the students. For the schools, they are also protected in the second part of the law, which talks about the fact that the schools must provide the student with an education that meets their needs, yes, but it doesn't have to be the most expensive, and usually that means the best of these options. If there are 3 options on the table and all of them meet a minimum level to provide that child with a fair education with regard to their peers, the school is allowed to select that option. My girlfriend works as a special needs teacher in Fairfax County. We discussed this law, and she, talked about how important it is for her families to have this ability to give their child a voice and to hold the school to a level of accountability that was previously not given to them. There are several students of hers that have lawyers that will come down intermittently and lobby on behalf of their students, and they use Fape as a basis for their arguments. And the teachers are in favor of this. They and the school, I'm sure, is as well. They have their eyes on the budget, but we're talking about people that are in this for the right reasons. And Fape, it seems, is a law that is backed by wanting to provide the best services that we can for these students. All right. Thank you.